Yes. All right, we're on the record.
Okay, good afternoon, everyone. My name is Justice D'Angelo. I am the single justice for this afternoon's session. The case number is 23-J474. This is an appeal of a bond, and Ms. Lavezzo, this is your appeal. The instructions are that both sides have 15 minutes. I have read all the paperwork, so you can get right into your argument after you're done. And again, you can use the full 15 minutes, but you don't have to. After you're done, Attorney Connors will go, and he will have his 15 minutes. There is no chance for rebuttal. Okay?
Okay. Okay.
So go right ahead, ma'am. I'll hear you.
Okay. Sorry, and I just unfortunately just had a stroke 2 weeks ago, so I'm not really the best. I can't really move my arm and my leg, so and part of my face. So if I start mumbling, I'm very sorry. But basically, this is about paperwork being turned in and non-rent payments, and unfortunately, or actually fortunately, I think that I'm being either lied to, or I really don't exactly know what's going on, because I have turned in all of my paperwork multiple times, by mail, in person. I've also sent them in through the e-file to the courts, and I'm being told that I never made any payments of rent, which is very incorrect. I have receipts from checks that were passed in, and basically I'm being told that I'm not doing the things that I'm doing, and I am doing them. There was this whole thing about the bond and having to pay this large amount of money that I unfortunately cannot come up with on my own. I'm not capable of getting a loan. I've been trying to get some sort of loan to try to pay it off for the past couple of months, and due to my credit, unfortunately, I'm just not able to. I can't even afford a car right now. So basically,
Let me interrupt. The housing court ordered a bond in the amount of $24,303.33, and in addition to that, paying use and occupancy per month.
Yes.
The judgment was just shy of $23,000, which the majority of that, from what I could gather, was rent. Now, you just said that you have been paying rent. How much rent do you say you've paid?
So I've been paying since we came up with the agreement in November. I was told I had to pay $370 or $390. I don't remember the exact number. But I was paying $400. I paid it at least 4 times, and then I went into the hospital due to having brain surgery. And then after that, I've had difficulty paying the rent, because when I bring in my checks, I told by the front lady that because of the court case that's going on, and because we're going back to court, they would not accept my rent.
So again, my question is, how much do you say you've paid in rent? Total.
Just like all together?
Yes.
Like since I lived here?
No. Again, and I could be wrong, and I'm going to hear from Attorney Connors in a little while, but the judge found that you owed $23,000. And that your rent through August was $1,304. So I'm asking you, why do you say the judge made an error in those calculations? What did he calculate wrong?
Well, the majority of the money is due to not saying that I didn't report 2 jobs, which is also incorrect. So that's basically rent built up from the 2 jobs. And then for, like I said, from December, I paid $400 in December, $400 in January, $400 in February, and then March. And then at the end of March, the beginning of April was when I went into the hospital. So I've paid all 4 of those months. And then since then, we've had issues making payments. So I haven't been able to make any payments after that, but it's not due to it's not due to me making a mistake. It's not having them take my money.
So you're saying they've refused? When you say they've refused to take your rent, who's refusing?
The front desk lady that I bring in the money to, I go in and I fill out the form, and halfway through the form, she sees my name and says that I cannot make a payment because, or not, they're not accepting my payment because of the court situation, because we were going back to court.
Okay. All right, and that's basically what you say the error is that the judge made. Is that correct?
Yes, I guess. Unfortunately, like I said, I don't have an income at the moment. I can't work. I'm out of work for a while. But I can, make the $300 payments that they said in the paperwork that they sent me. And then I was hoping I could maybe add on like a back rent, like we did before. I'm still not exactly sure where the agreement went wrong, because I was told I wasn't making payments and I was making payments. So that's what I'm assuming was why we were brought back to court. And I believe that it's very wrong. I'm sorry, but I do.
All right, and you told all these issues to the judge in the housing court and showed him all the documents?
I didn't physically show him the documents, but he asked me if I had them, and I said yes. But he didn't ask me to hand them over to him or anything like that. No. But I have, like I said, I have sent them in to housing. I've sent them into the courts. I physically had them with me when I went to court last time.
Okay. Is there anything else you want to say before I hear from Attorney Connors?
Not really. I guess you have the gist of the story. Like I said, unfortunately, I'm not making any money because I'm out of work due to illnesses that are going on, and they're going to be taking a while to get better. I do have a boyfriend that is willing to help me make payments. So I do have some backup, but unfortunately, he's the only backup that I have at the moment. So like I said, if I get thrown out or if I get told that I can't live here anymore, we unfortunately don't have anywhere to go. And it's, I have an 11-year-old son that, is in school, and and like I said, my health issues, I can't really, I'm supposed to be on bed rest for a while and recovering. So I just have a really strong feeling I wouldn't be able to move.
Okay. All right. Thank you very much.
You're welcome.
Okay, Attorney Connors, I'll hear from you.
Good afternoon, Your Honor. Attorney Connors on behalf of the Waltham Housing Authority. And speaking to the issue she just raised, that we did acknowledge that she made some payments in the spring of 2023, and we told the court that. I think there was some confusion. The Housing Authority didn't think they could accept the payments, but we did. We did, in fact, accept payments, and there were 4 payments made in the spring of 2023. There was $400, $400, $300, and $400. So those were all accepted, and those were credited against her rental balance. And I think the judgment issued after that, because we made that presentation to the court at the motion where we asked for the court to issue an execution. So the majority of the back rent after that, after giving her credit for those payments, was $19,557.90. And I think that's what the court judgment reflected. And then the court added on use and occupancy that it continued on from that day. But going back to the reason why we're here, Your Honor, I would say that, number one, what was filed with the court was a mystery to me. There's a lot of blank documents. It's not articulated as it's an appeal of the bond, or the denial of the waiver of the bond is simply characterized as a motion for stay. But I just didn't see anything in there that raises issues of an appeal of the court's decision not to waive the bond. But putting that aside, I realize that the court has the full authority to review this de novo. And I would say, number one, the first issue is for the court to determine whether or not she's indigent. I didn't really make it an issue of that at the lower court. She probably is, but I've been at a miss to find an affidavit in here that articulates that or states that she's indigent. And that's part and parcel of the problem with Ms. Lavezzo. She fails to provide paperwork when we request it, and that's kind of led us down this road eventually. So I would say she's failed to provide the proper paperwork to establish that she's indigent. She's failed to establish a reason for where she has a defense that is not frivolous. She hasn't suggested anything other than she says she had an agreement. She did have an agreement. We had an agreement for judgment that was entered by the court in November of 2022. We filed a motion in January of 2023 asking the court to issue an execution. 2 months later, we had that hearing. The court issued the execution. Then there was a motion for reconsideration filed by the defendant. There was a second hearing, and the court found in the text of their order that they found that there was nothing to suggest that anything had changed, that she had been given a full opportunity to be heard at the first hearing and at the second hearing, and he found no reason to reconsider the judge's decision to issue the execution and the judgment. And just procedurally, that was appealed to the single justice, and the justice found that the court issued the execution in error, and so the execution was returned, and then an appeal was filed, and that brings us back here again. But I would say that this case has been going on for 2 years. The initial court was filed in September of 2021 in the Waltham District Court. And then after 2 continuances to accommodate the defendant, she transferred to housing court, which was her right. But then a year later, so now year 2, we're in the housing court in November of 22, November 22nd of 2022, we entered an agreement for judgment. So it was the defendant's choice to enter that agreement. There was a judgment right in there which says what the back rent agreed is. It's right in the judgment, right in the agreement for judgment. And she admitted that, and she signed it. And that was up to $19,000, let's say, in the agreement for judgment.
I saw that in the paperwork, counsel. I understand.
$20,359, and an agreement to pay $326 on a monthly basis. So she didn't pay the $326 in a timely manner. She did make some subsequent payments, which I admit she did pay them, but none of them were timely except for the 4th one. So in the calendar year 2021, Ms. Lavezzo paid rent once. In January of 2021, she paid $439, didn't pay for the rest of that calendar year. In 2022, she never paid $1. She did receive $5,900 from Metro Housing, but she never paid anything. And there was an assessment of $9,000 in addition to her regular rent issued against her based on unreported income. And again, that was captured in the agreement for judgment. That was part of that financial judgment in November of 2022. She didn't dispute that. But the RAF money was applied towards that, yet still she owed $20,000. So in calendar year 2022, she made one payment, which was from somebody else, not her. And then in this 2023, as I stated, there was 4 payments made. And of course, those payments were made late. The court issued, denied her motion for reconsideration, and they didn't really do it in the text of the order. Effectively, they had to go back and do that a couple months later, which triggered this appeal. But essentially, the judge found that there was no basis for reconsideration, but he granted a stay. He granted an alternative relief. And yet he said then she should continue to make the 326 use and occupancy payments, and she hasn't paid anything. So I filed an affidavit with the court. I filed several affidavits with the court, but most recently, May, June, July, August, September, 0 has been paid. So based on the case law, as you know, it's the case is Bank of New York Mellon. It sets out kind of issues that the court ought to consider when dealing with the issue of whether or not to waive a bond and whether or not to set a use of an occupancy. And I would say the fair market value of the property is over $2,600. Now, that was an issue in the court case. I filed as an exhibit, an attached exhibit for a 2-bedroom property in the Boston, Cambridge metro area, of which Waltham is included. It's over $2,600. The merits of her defense, she hasn't raised any meritorious defenses. I would say, number one, the agreement for judgment is almost unappealable because all issues were waived. And then it was really up to the court to determine whether or not she substantially complied with that, and whether or not there was a material breach of that. And the court found not once, but twice that she did. So I don't think that's before the court. So on what she's filed with this court, she hasn't raised anything other than to say she had an agreement, and she says she filed paperwork, which we should dispute that she did. And the court found, in our favor on that, on 2 occasions. And the number of months that she hasn't paid rent is, as I said, calendar year 2021, it was 1 payment in January. Calendar year 2022, there was 1 payment. So, and this year, 4 payments. So there's substantial number of months that she's failed to make any payments. And she hasn't raised a meritorious defense. She hasn't really raised a defense at all. She did also make mention of a mice issue. And we've sent out exterminators. And we put that in the affidavit. They went out in May and they went out in June of 2023 to treat the property, but they can't get rid of the mice if there's sanitation issues in the apartment. And that's even reflected in the documents that the defendant filed with the court, that she's failing to keep a sanitary apartment. So we can't kill them if she doesn't cooperate with us. There was another issue of real estate taxes on the property. This is a nonprofit, so that's not an issue. But the expected duration of litigation, I'd say, I'm going to defer to you. I would believe it would be another 6 months. I mean, I know from the date between now and the hearing date, and then there'll be at least 90 days post-hearing date for a decision from the court. So again, we're here and we haven't received a payment since April of 2023. And we're going to look at another 6 months. Now she owes us over $24,000 as found by the court. And I think the judge is correct in that she hasn't made any use and occupancy payments since the hearing. So we're entitled to that as well. And the 326 is well below the fair market value. I would say the fair market value is 2,600, but we're not realistically asking her to pay $2,600, but we're asking her to pay $326 per month, which she hasn't done. But the reason for that is that was agreed to in the agreement for judgment going back a year. Number one. Number two, the Code of Mass Regulations regulate that the rent shall be determined based on her income. And then if she fails to provide accurate income information, then the housing authority has the right to charge whatever her last redetermination amount was. And that's where we get the 326. So that's going back to January of 2020. Now, in the meantime, you'll see in the affidavits that the agreement for judgment contemplates that her boyfriend, Christopher Curtin, doesn't live there. And so if he doesn't live there, then his income is not attributable to her rent. That representation was made to us. It was made to the court. It was signed by the defendant. And then when we asked for that evidence in the agreement, she couldn't provide it. And they actually said, you know what, he does live there. And then he provided income information. So if we attributed that, that was $1,100 right there. But we don't know if he's still working, but I believe he's still there because it's in the court order of stay that he has a right to stay there as a caregiver. So her rent has never been properly computed based on her income, based on the income of Christopher Curtin. So the last most accurate one we have is $326. So we would ask that the court to deny the motion because based on the 6 criteria set out in the last one was a financial condition of the parties. I understand that Mr. Lavezzo probably doesn't have a lot of funds, but the housing authority is not a for-profit entity. They're a public housing authority that's dependent on rental income from their tenants, as well as the subsidy from the state and the federal government. So they don't have, they're not awash in cash. They're trying to, keep these units for people that need them, that are also willing to make their contribution to the rent based on their income. And that's what we asked this defendant to do when she hadn't done it. So we would ask that the court deny the appeal of the waiver of the bond because like the court in the housing court, like the judge in the housing court found, she hasn't offered a non-frivolous defense. And then based on the other factors from Bank of New York Mellon, there's plenty of other reasons. The length of time that we haven't received a payment, the merits of a defense, the expected duration of litigation. So I think it's only fair that this case has been going on since September of 21. Here we are in September of 23. It's a 2-year-old case. She pays rent over the course of the year 6 times. That's 36 months, 30 months haven't been paid. And we believe that that's just simply going to continue on, and this is not a good reflection on the housing authority when the other tenants see that, people can get away with not paying rent and not doing anything. So respectfully, Your Honor, we would ask that the court deny the defendant's appeal.
Okay, thank you all very much. You'll